Well, there has been breaking news on the Alex Murdaugh case, and that is that there has been an official evidentiary hearing date set, and that is going to occur as it stands right now, January 29th, to continue until all of the evidence is presented regarding the alleged jury tampering from the court clerk, Becky Hill. Now, there is a status conference scheduled for January 16th, so that date could change of the evidentiary hearing, but as it stands right now, that the date for the evidentiary hearing is January 29th, coming up really soon. So exciting stuff. Now, for the viewers of my channel and the subscribers of my channel, this is not so much of a surprise. As I've been saying already for months, as soon as I saw that motion by the defense, the attachments that they sent, the affidavits that they attached from the jurors, right away, I was telling you that I'd be surprised if there's not an evidentiary hearing. So I'm not surprised there is an evidentiary hearing, and that's also why when you're a subscriber of this channel, you get to be a step ahead of the game. And not only that, but today, I can guarantee you, today, you are going to understand what you need to know, and you're going to be much further ahead of anybody else who's been following this case. And that is because I did a deep dive into the law on this, and you are going to be just as well situated as the judge is going to be on this case. Unfortunately, you're not going to be presented with all the evidence. There's going to be a lot of evidence that's going to be presented that we do not see, but you're going to understand how the judge is required to look at the evidence coming in and to make the ultimate decision of whether to grant a new trial based on the evidence that she's going to be receiving in these evidentiary hearings. So you need to understand the law behind this. I'm going to explain it all very clearly, and by the time we're done, I guarantee you are going to be in a better position than anybody else who's been following this case if they haven't seen this channel as well. So before we jump into the main issue, which is what the label of this video is, that it all comes down to one thing, and it's true, it all comes down to one understanding of some very important laws as it relates to jury tampering. It all comes down to one very basic understanding of the law, and we're going to get into that in just one moment. But it's important to first take a step back and understand where we are, because people have been hearing, things are being filed. At one point it was in the Court of Appeals, now it's back in a different court, and now there's a different judge assigned. You can be lost in just simply the procedure. Where exactly are we? What's going on here? And what has just been filed? There's been 2 additional filings that were just filed by the Murdaugh team and by the state. What's going on with all these filings? Is there anything new going on? What's happening? So let me just set the stage first before we jump into the substantive arguments that are being made by both sides. Okay, so let's remember where this all started. This all started with the conviction, right? Alex Murdaugh is convicted, sentenced, and now there's an appeal that's filed. There's always an appeal filed on a conviction of a murder case where someone's going to be sitting the rest of his life in prison. You've got to exhaust all of your possibilities to get out, so you got to file an appeal. So they took it from the trial court level, and his team, the Murdaugh team, filed an appeal. Now, jurisdiction transferred from the trial court level to the Court of Appeals. So now the Court of Appeals had jurisdiction over this case. Then what happened is the Murdaugh team filed a motion to stay the proceedings, meaning telling the Court of Appeals, stop everything, just put a pause on the appeal, send the case back to the trial court level, so now the trial court level can have jurisdiction again, because we need to file this motion for a new trial. And they had to attach that motion for a new trial as an exhibit to their motion to stay at the Court of Appeal level. So at that point, it was just an exhibit of their motion to stay proceedings at the Court of Appeals level. The Court of Appeals granted that motion to stay and sent the case back to the trial court level. So now it's on the trial court level. So then the Murdaugh team filed a motion for a new trial with the trial court, because now the trial court has the jurisdiction. So all they really simply did was, instead of labeling it as an exhibit in the motion to stay at the Court of Appeals level, now they just filed it as a regular old motion in front of the trial court judge. Now, while that was also going on, they filed a writ of prohibition with this Supreme Court, asking the Supreme Court that Judge Newman not be allowed to hear the case for a number of different reasons. And we spoke about all this in previous videos that I did on the Murdaugh case. Go check that out if you want to get a full analysis of everything that was going on. But so they filed this writ of prohibition, and again, the Supreme Court granted that writ of prohibition. Judge Newman is not going to be hearing this case, and in fact, they transfer the case to a completely different judge. So they have this new judge that's appointed. The judge is, let me just get the name here, Judge Jean Toll. So now Judge Toll is going to be hearing just the, as it stands right now, my understanding is that she is just going to be hearing the motion for a new trial and preside over the evidentiary hearing if she decides to grant one. So first she was just given the authority that she is going to be appointed, instead of Judge Newman, instead of any other judges, she is going to be appointed to hear this motion for a new trial. So she entered an order saying that there is going to be an evidentiary hearing. Okay, so now we're basically just back at the trial court level. There's a special judge that was appointed to hear the motion for a new trial, and she decided that, if you've been following this trial, she decided that, following this channel, then she decided that, okay, great, we're going to have an evidentiary hearing exactly as Brother Counsel has said on his channel. Of course, we're going to have an evidentiary hearing. So that's what she determined. Now, let's stop it right there. That's all she determined. We're going to have an evidentiary hearing, and she scheduled it for January 29th. Now, something that you have to know. Sometimes before an evidentiary hearing like this, or sometimes before a trial, the judge will put it in order, and she'll send it to both attorneys and say to the attorneys, I know we're going to have a trial, and everything's going to come out during the trial, and I'm going to present witnesses and exhibits and all that good stuff. But I'd like to have a brief. I'd like to have a brief beforehand, laying out the factual basis for the claims. I'd like to know some of the legal arguments that you'd like to make about different pieces of evidence coming in, or legal arguments about why you're right or why you should win, or why the other side is wrong. So I want just a brief, catching me up to speed, so to speak. So that sometimes will be ordered by the judge. Now, it does not appear that that's what the judge ordered in this case. I was looking for an order to see whether this judge ordered both sides, the state and the Murdaugh team, to submit pre-evidentiary hearing briefs, and I didn't see that. So there's no order to do it, but the Murdaugh team took the liberty to do it anyway. So technically, can this entire filing be stricken? Yeah, technically it could be. Now, is the judge going to strike it? Probably not, because why not? I'll read it, I'll see what they have to say, and I'll read it, because why not? This is what I was appointed to do. So, I mean, if she really wanted to, she could say, well, I never ordered you to file this pre-evidentiary hearing briefing, and therefore it's all stricken, I'm not reading it, and you just show up at the evidentiary hearing. But still, they took the liberty to go and file this brief, maybe because they get the bill for it, or for, it actually, hoping that the judge will actually read it, then they'll be able to convince the judge that they're right. Right, so the Murdaugh team did that, and then the state also did that, because you don't want to be the one attorney that didn't do it. If the other side did it, then you're also going to want to do it. So the Murdaugh team did it, the state did it, so they, on their own, filed, which is what the new filing is, a pre-evidentiary hearing brief. So basically, to make things simple, all we have right now is we have the motion for a new trial that was filed, we have the response to that by the state, and now we have two new filings, both pre-evidentiary hearing briefing. And of course, if you're the Murdaugh team, what are you going to be doing in this pre-evidentiary hearing briefing? You're not just going to give the judge the reasons why you win, but you're also going to try to attack the state's position. So the state responded to your initial motion for a new trial. So part of what you're going to be doing on the Murdaugh team is to respond to some of the attacks that the state levied against you in their briefing, in their response to your motion for a new trial. And that's exactly what they did. Now, we all remember that part of the state's attack on the Murdaugh team's motion for a new trial was they attacked the affidavits that were attached. Now remember, there was one affidavit that was signed by an actual juror. So we have the Murdaugh team attaching one affidavit that was actually a sitting juror who actually sat during deliberations. That juror was no problem signing an affidavit by herself or himself. I'm not sure if it was a woman or a man. Then we had an affidavit that was filed by a paralegal of the Murdaugh defense team. So this paralegal took certain jurors' interviews. She wrote what they told her down, and then she herself, the paralegal, filed an affidavit with the court saying, this is what the jurors told me. So the state attacked that affidavit that was filed by a paralegal of the Murdaugh defense team and said that it's hearsay, right? That's textbook hearsay. You're just writing down what somebody else told you. You don't have any personal knowledge about this. You're just writing down what this other juror told you happened. And that's what you're filing with the court. That is hearsay. Now, if you'll recall, I discussed that argument in one of my previous videos about this, and I said that that argument really should not fly. It shouldn't really fly that much. Why not? It sounds like an amazing argument. It sounds like it's hearsay. We all know the rule against hearsay. You're not allowed to have, it's not admissible. You can't admit that into an evidentiary hearing. You can't admit it into trial. So why should you be able to admit that as part of a filing? And I explained to you that there's a difference between trial proceedings, evidentiary hearing proceedings, and what you're attaching as an exhibit to your motion. So when you're filing a motion in front of a court, or you're filing any sort of briefing in front of a court, and you want to show them that you're actually serious about this, and people actually are willing to take an oath and say what actually they're saying in their affidavit, so then you're just showing the judge that we're taking this very seriously. There are people here that are willing to take the oath. They're willing to take the stand and say what happened. So the affidavit is just to set the tone with the judge to say this is a serious issue and we're going to need an evidentiary hearing. And if we have an evidentiary hearing, then of course we're not going to rely on these affidavits. We're not going to rely on what these different levels of hearsay. Of course, at that point, when we're actually having a formal proceeding about this, then of course we have to follow all the rules of evidence. And we're going to actually call those jurors themselves to give testimony on the stand. So it shouldn't bother the judge, it shouldn't bother the court that a paralegal for the Murdaugh's defense team is saying in her affidavit what the jurors told her and then filing that with the court. So that's what I explained. Now, I don't know for sure if the Murdaugh team is following me on my channel and listening to what I have to say. Of course, if they're smart, they would be, and so would the state. They'd be following what I'm saying. But this is the exact argument that the Murdaugh defense team made in their pre-evidentiary hearing briefing. Now, it's a 20-page brief. I'm not going to go through all of it. We're going to talk about, again, the main issue. But this was interesting because they literally, essentially, said exactly what I argued. And here, I'll just read it for you. First, the affidavits of Holly Miller were offered only as evidence as to what certain jurors would say if called to testify at an evidentiary hearing. Of course they are hearsay. All affidavits from persons who have not yet testified in court are hearsay. This is also a point that I made. All affidavits are hearsay. There's no affidavits that are being admitted into court in a real trial or in an evidentiary hearing. There's no affidavits that are being admitted. It's textbook hearsay. Any affidavit, even if it's based on your own personal knowledge. I saw this with my own eyes and I put it in an affidavit. That is hearsay. It's not admissible. And all trial lawyers know that. So this is what they're saying. They're saying, of course, they're hearsay. All affidavits from persons who have not yet testified in court are hearsay. Hearsay is just an objection to the admissibility of evidence. It's not a basis to strike a filing, right? They're saying you're completely convoluting the two concepts. There's a concept of a hearing where things have to be actually run with rules of evidence, and then there's filings. Filings don't have to follow all the rules of evidence. The purpose of Ms. Miller's affidavits was to help obtain an evidentiary hearing, which has been accomplished. Obviously, they cannot prove Mr. Murdaugh is entitled to a new trial. They're not saying that we should be entitled to a new trial because of this affidavit. All they're saying is we need an evidentiary hearing. And of course, at the evidentiary hearing, then we're going to present real testimony. And at that point, that's when we're going to prove that Mr. Murdaugh needs a new trial. Witness testimony in a courtroom will do that. Okay, so that's essentially the exact argument that I was telling all of you. So again, you are, like always, a step ahead of the game. And that's what puts you in a great position when you're watching this channel. Okay, now let's get to the main issue. This is where it all comes down to. It all comes down to your understanding of a specific area of law. Okay, and you're not going to get this anywhere else. I can guarantee it. And if you do, then some other lawyer there is doing an amazing job, just like me, because I actually did some research on this. I looked up the cases and I analyzed it all, and I'm going to break it down and give it to you. And this is just, it's really, really cool stuff. If you like this kind of stuff, then you should apply to law school tomorrow. If you don't like this kind of stuff, law school is not for you. This is what I find very exciting and very enjoyable. And this is what it all comes down to. Okay, let's start. There's a case called Radner versus United States. Now, Radner versus United States is an opinion which was authored by the United States Supreme Court in 1954. This is where all this fun begins. Okay. Now, in the Radner versus United States, actually, that case itself has a very interesting procedural history, and we can do a whole video just on what happened in that case and the different levels. It went up and went down and went back up. It was very interesting how that occurred, and also a lot of lessons that we can be learned. But this is not a law school class right now, so we're not going to go through the case like that. But I want to bring out the main point from Radner. Radner versus United States, which based its opinion on a case called Maddox versus United States, which is an 1892 case. So this is law that was like really, really early on. And like I always say in my videos, it doesn't matter how early on, how old the law is. In fact, just the opposite. If you have a law that's been in the books forever and nothing's ever changed about it, then that shows how great and strong that law is. So this is what Radner versus United States said. I'm going to read it for you. It has to do with jury tampering. What happened, well, let me just give you some quick facts. What happened in Radner versus United States is that there was a trial, and one of the jurors was approached by an unnamed person. We don't know who this person is. The juror was approached by a person, and that person essentially bribed the juror. Said, if you vote not guilty, you're going to benefit financially. So it was essentially a bribe. Vote not guilty, and we're going to take care of you. Okay, that was what was told to the juror. The juror reported that. Good for that juror. Reported that conversation, and now this is what this court was stuck with. What are we going to do in this situation? So this is what Radner versus the United States said. In a criminal case, any private communication, contact, or tampering, directly or indirectly, with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. So, it is presumptively prejudicial, which means any comment, any private communication, any comment, or tampering, what you want to call, with a juror, is automatically going, and it has to do with the case, is automatically going to be considered prejudicial. We assume that it's prejudicial. There's a presumption that it was prejudicial. So all you have to prove, if you're the defense, all you have to prove is that there was a communication with a private communication with a juror about the trial, and then automatically you have a presumption that that communication prejudiced that juror. But the opinion continues. The presumption is not conclusive, meaning we don't say we for sure are going to say that it was prejudicial. It's not conclusive yet. But the burden rests heavily upon who? This is important. The burden rests heavily upon the government, or the state in this case, to establish after notice to and hearing of the defendant that such contact with the juror was harmless to the defendant. So, the way this works, under Radner, this is the basis for everything. The way it works is, if there was any communication with a juror about the details of the case, there's automatically a presumption that it was prejudicial. So if the defense just shows that there was a communication, it was about the case, then there's a presumption that it was prejudicial and it affected the juror. Now the burden shifts to the state, and the state now has to prove that that communication was harmless to the defendant. So the burden shifts. That is Radner versus the United States, based on the case Maddox versus the United States going back to 1892. So this is really where it all starts. This is where all the fun begins. Okay, now let's get to the first, and since we're in South Carolina, we're going to be talking about some of the South Carolina Supreme Court cases. Now remember, there's two different systems here, something also that you should just know for basic knowledge. There's the state system, so every state has a system of courts. We have district courts, we have circuit courts, we have court of appeals, and then the Supreme Court of that specific state. Every state has their own Supreme Court. And then there's also the federal system. The federal system has different districts, they have circuits, and then also Court of Appeals, and then they have the United States Supreme Court, right? So that's but just because the United States Supreme Court is in the federal system doesn't mean that their holdings are not going to have some serious ramifications on state cases as well, especially when you're dealing with due process, which is more of a federal statute. I mean, there's state statutes also about that, but the point is that what the United States Supreme Court says is pretty heavy, weighs very heavily. Okay, so now we have the next case, which I want to talk about, is something called State versus Green. Now, both sides, the Murdaugh team, they talk about the Radner case, and so does the state talk about the Radner case. You can't not. When you have a jury tampering allegation, Radner versus United States is the beginning of the analysis. But then they have another case called State versus Green. They both discuss this case. What happened in State versus Green? State versus Green is a case that happened in South Carolina. So it's a South Carolina Supreme Court case. Here, what happened is that there was a trial and the jury was deliberating. And one of the jurors asked the bailiff, just curious, like what would happen if the jury was deadlocked? They were just curious. They didn't even start the deliberations. Maybe they started a little bit, but one of the jurors was just curious and said, just said, what would happen if the jury was deadlocked? And the bailiff, instead of saying, any question that you have to write down, and I'm going to take it to the judge, the bailiff decided to answer the question himself. And the bailiff answered, well, if you're deadlocked, the judge will most likely give you an Allen instruction. Well, what's an Allen instruction? An Allen instruction, basically, if you have a jury that's deadlocked, the judge will call the jury out and they'll say, keep an open mind, listen to other jurors, try to figure out where you can meet and just keep deliberating. It's essentially just keep at it, guys, keep an open mind, try to be reasonable with each other, try to see from different angles, from different perspectives, and maybe that will change your mind. That's basically what the Allen instruction is. So that's what the bailiff said. The judge will probably give you an Allen instruction. Now, here you have a communication, which was about the case, and the defense it's easy to prove. The bailiff will acknowledge that they had this conversation. So right automatically, the burden should shift to the government to prove that communication wasn't harmless. And that's a very high burden. How do you prove that communication was harmless? But State versus Green said that in this specific case, you don't even get to the Radner presumption. We don't even qualify for the presumption in this case. And this is what they say. We are not persuaded that the Radner presumption of prejudice applied here. We readily agree with the Court of Appeals that the state overthrew any presumption of prejudice, meaning the Court of Appeals was the lower level court. The Court of Appeals said there was a presumption, but the government overthrew that presumption. And they proved that conversation was harmless. It probably was harmless. What does it have to really do with anything substantive of the case? Nothing. It's just about what we're going to do if we're deadlocked. So the Court of Appeals essentially said, yeah, maybe there is a presumption under Radner, but the government was able to overcome that. So the Supreme Court is agreeing with the Court of Appeals that if you would have followed the regular course here, that Radner tells you that there's a presumption, and now the government has to overcome that we agree with you that the government did that. But this is what they say. We readily agree if it applied. In this regard, we join the Court of Appeals in commending the trial court for its deft handling of the issue. Okay, and then they just talk about that the trial court questioned each juror and the bailiff, which proved there was no reasonable possibility that the bailiff's comments influenced the verdict. Okay, but this is what gets interesting. Our unwillingness to categorically apply the Radner presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error. So what they're saying here is just because there was an inappropriate comment, you're right, it was inappropriate. The bailiff should have never said it. But just because there's an inappropriate comment does not automatically give you that presumption. It doesn't do that. So Remmer, right away, they're chipping away at Remmer, because Remmer was very clear. Any communication, any private communication about the case, anything, is going to automatically create that presumption. Now, State versus Green is saying, no, not every single communication, even an inappropriate communication, is not automatically going to get you to this presumption that it was prejudicial, and now the burden shifts to the government. It's just not going to do that. And then they say that in Remmer, it was much more serious. There was an actual bribe, so that's straight to the merits of the case. And this was just about, what should we do if the jury is deadlocked? So yeah, it was improper. The bailiff should have never done it, but you do not qualify for this presumption. So both sides use this case, right? We got the state trying to use this case and saying that any of these comments that Becky Hill made doesn't even rise to Remmer. It's like the bailiff saying that if the jury is deadlocked, then the judge will probably give you the Allen instruction. So by her saying, watch his body language, or any of those allegations that were made, it's not really serious enough to rise to the presumption that Remmer gives you. Now, of course, the Murdaugh team is saying just the opposite. They're saying, no, in State versus Green, it was such a innocent comment about what to do. Here, she's actually telling them not to believe Murdaugh and watch his body language, and that you shouldn't be fooled by him, things like that. Obviously, that is much more serious than the bailiff saying, well, we would give you an Allen instruction. So they both use the State versus Green case, but what I thought was interesting also, just to point out for the legal scholars out there, is that you see right away that State versus Green is already chipping away at what Remmer versus United States, which is based on Maddox versus United States since 1892, already is, and this is a 2020 case. So in 2020 already, this is, not already, but in 2020, they're kind of chipping away already at this Remmer holding. So now we get to the real conundrum here. This is where it's all at. This is what it's all about right here. Now we've discussed Remmer, we discussed State versus Green, which kind of chips away at it, but this is where it really gets fun. You've got Remmer versus United States, which very clearly says any communication that's about the case automatically creates this presumption to, and the burden shifts to the government or the state to prove that that communication was harmless. Then we have this other case called Smith versus Phillips. Smith versus Phillips is also a United States Supreme Court case. So we're not talking about the United States Supreme Court, which is the highest court of the land, and some lower court out there that decides that something's different. No, these are on the same level court, the United States Supreme Court. So you have Smith versus Phillips. Now in Smith versus Phillips, the court says the following. Listen closely. The court has long held that the remedy for allegations of jury partiality, again, same issue, whether there was juror tampering, and this is what they're saying about what the court has long held. So this is the Smith versus Phillips court saying, this is what we've always held. This is what the United States Supreme Court has held since 1892. Now, if you were saying what the United States Supreme Court has long held, what would you say? Exactly the standard that we just said in Remmer. But listen to them. Listen to this. The court has long held that the remedy for allegations for juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. Excuse me? What does he have to prove? Actual bias. Hold on a second. Hold the phones. That's not what Remmer said. Remmer said all they have to prove is that there was a communication about the case, a private communication about the case. And then automatically there's presumption, and the burden is on the government to prove that that communication was harmless. But here we have Smith versus Phillips saying that we have long held that all you have to do is have this evidentiary hearing, and at the hearing, who is the burden on? The burden's on the defendant. To prove what? To prove actual bias. What in the world is going on here? What did they have for breakfast that morning? And then they say, it would be one thing if they say, and we're overruling Remmer. But they don't even do that. What they say is, for example, in Remmer versus United States. So they're bringing Remmer versus United States as a proof to this concept that the defendant has to prove actual bias. So as they say, for example, in Radner versus United States, a juror in a federal criminal trial was approached by someone offering money in exchange for a favorable verdict. And that's actual bias. So this is where the conundrum is. This is a real problem. Because you have United States Supreme Court Radner saying one thing. Now you have Smith versus Phillips saying another thing. And then Smith versus Phillips is saying that that's actually what Radner is also saying. So what exactly did they have for breakfast that day? That's my question. But it doesn't matter what they had for breakfast, because at the end of the day, it is a published United States Supreme Court opinion. So now you've got two completely different tracks, two completely different standards. Either you have just to prove that the defendant just has to prove a communication occurred, and that automatically shifts the burden to the government of the state, or under Smith versus Phillips, you have to prove that it actually biased the juror. That's very hard to prove. How do I prove that this communication actually biased the juror? That's a lot harder. I have to ask the juror, well, would your vote have changed? How did that change the way that you looked at the case? Things like that. That's not something that the defendant wants to get into. Not only that, but there's another case, United States versus Olano. And this is a case that was not quoted in either of the briefs. And if I was the state, I would have quoted this case, because this case says the same thing as Smith versus Phillips. So Smith versus Phillips was in 1982. United States versus Olano was in 1993. And there's been a whole bunch of different cases that go in the same way as Smith versus Phillips. They analyze it the same and say that you have to prove actual bias. So what do you think the Murdaugh team is what position they're going to take? They're going to take that Radner is right. The way that Radner essentially says it straight out explicitly itself, without the way that Smith versus Phillips interpreted it. And the state is going to say that no, Smith versus Phillips is the right way to go, and that's the way that you have to, that's the burden that the defendant has to prove during this evidentiary hearing. So what is the judge supposed to do? Is the judge supposed to follow Radner, or is the judge supposed to follow Smith versus Phillips? This is the conundrum, that no matter what type of evidence comes in, this is what the judge is going to have to figure out what to do. And regardless of what the judge does in this evidentiary hearing, I can almost guarantee you that it's going to be appealed. Because it's a very big difference whether the burden is on the defendant or the burden is on the state. And eventually it's going to come back to the South Carolina Supreme Court, and they're going to have to deal with this conundrum. Now, just to add insult to injury here, if this is not confusing enough, we have a South Carolina Supreme Court case in 1993. It's called State versus Cameron. And State versus Cameron all of a sudden created a new standard. Okay, if this is not confusing enough, that we have the shifting burden, there's a presumption of presumption that the communication was prejudicial. Now the burden's on the state, or is the burden on the defendant that they have to prove actual bias? So we got that problem. But now we have State versus Cameron. And the Murdaugh team loves this case, because this is what State versus Cameron says. In this case, I'm quoting from State versus Cameron. There was the private communication of the court official to members of the jury. So it was a similar situation where you had a communication of the court official to members of the jury. An occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. When there has been such a communication, listen to this. When there has been such a communication, a new trial must be granted, unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. So now we have a new standard, that all the defendant has to prove is that there was a private communication, and the communication was about a subject matter of the trial, which was not harmless. So it's about something that had to do with the trial. And then a new trial must be granted. So now we have a whole new thing. Hold on. There's no shifting burden anymore? There's no, now the state has to prove anything? No, there's none of that. And this is a South Carolina Supreme Court case which says this. So the Murdaugh team loves this. They say, look, we don't even have to, all we have to prove is that there was a communication. It was about the subject matter of the case. The communication was very clearly not harmless, right? Only if the communication was clearly harmless, then they don't get a new trial. But if the communication was about a subject matter which was not clearly harmless, which would be like watch his body language or don't let him fool you, things like that, then this case says that a new trial must be granted. So now we have another curveball to throw in here. What should we do? Should we follow State versus Cameron? If we follow State versus Cameron, then you can completely ignore Remmer, you can ignore Smith versus Phillips, and just concentrate, okay, what was the communication about? And that's it. New trial has to be granted. So it doesn't seem, in my analysis, that State versus Cameron followed anything to do with Remmer, didn't follow Smith versus Phillips, completely ignored the whole analysis that was required. And they just said, well, if there's this communication, then a new trial has to be granted. It seems to me that that's clearly wrong. Nevertheless, it's a South Carolina Supreme Court case. So it has some pretty strong precedential value. So that is State versus Cameron. Now, this is where it gets even better. Now, okay, let's just pause for a second, okay? So if you are the Murdaugh team, or if you're the State team, instead of laying out in your brief saying, Smith, we have Smith versus Phillips, which says yada, 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 right? Instead of saying that, what I think is a better way to approach this is telling the judge, look, we have this friction. We all understand what's going on here. We've got Remmer, which helps the defense team. We've got State versus Phillips, which helps our team. And we have these two conflicting ways to approach an evidentiary hearing about who the burden is on when it comes to jury tampering. And then what you should do is, you say, we got these conflicting issues. And now you say why, even though they're conflicting, Remmer versus United States and Smith versus Phillips, even though they conflict with each other, but there's reasons why you should follow one as opposed to the other. That wasn't done. All you have here is the Murdaugh team arguing Remmer, saying, oh, Remmer. And don't worry about Smith versus Phillips. That's just it's distinguishable for whatever reason. And you have the State saying, oh, just ignore Remmer. We have all this other stuff. Don't do that. I think you should say, we've got both. We got a problem here. Remmer is good law, and so is Smith versus Phillips. And there's an obvious contradiction here. And the way that other courts have resolved this type of contradiction, or the way that the courts in South Carolina has resolved this contradiction, is by following one way or the other, and then show other cases which say, look, even though they acknowledge that there's been a conflict between Remmer and Smith versus Phillips, this is how they resolved the conflict. They didn't do that. And not only that, this is where it gets even better, if it can even get better than this. It gets a little better. And this is how it gets better. There's a case called State versus Barreros. Might be butchering it. State versus Barreros, which is a Connecticut case. It's Berrios. State versus Barreros. Now, it's a Connecticut case. Now, what is a Connecticut case doing in this brief? That's a question that you should be asking. And you have to understand, as a lawyer, when you're filing something, you want to look for cases in your jurisdiction. So if you're in Michigan, you got to quote Michigan case law. If you're in New Jersey, you got to quote New Jersey case law. If you're in Florida, you got to quote Florida case law. Telling a Florida judge that there's some case law in Michigan, there's some judge there that ruled a certain way with this similar factual scenario, the Florida judge will say, okay, well, what does that have to do with Florida? We're in Florida now, not Michigan. So why would you ever quote a case that is out of your jurisdiction? And the reason for that you would do that is if you have what we call an issue of first impression. An issue of first impression means that this is the first time that the courts had to deal with this type of issue. Or this type of issue doesn't really have any case law in our jurisdiction to deal with it. It never came up. And therefore, you've got to look to other jurisdictions and how they dealt with this specific issue and how they analyzed the law. And then you're going to ask the judge to adopt the way that these other jurisdictions dealt with this. So one of those issues in this case is, what is the burden of proof? As I always talk about in all my videos, you got to know what the burden of proof is in the proceeding that you're in. So if you're in a trial for a criminal case, you have to understand that the burden is beyond a reasonable doubt. If you're in a trial for a civil case, then generally speaking, the burden is preponderance of the evidence. So what is the burden in a case where you have jury tampering and you have an evidentiary hearing regarding that jury tampering? What is the burden of proof? And here, the Murdaugh team, what burden of proof do you think they want to have? They don't want to have a very heavy burden of proof. If it's beyond a reasonable doubt, that's very hard to prove, right? So therefore, they want to show the judge that the burden of proof in this evidentiary hearing is much less than that. And therefore, they make the case in their brief that the burden is only a preponderance of the evidence. Preponderance of the evidence is, simply put, more likely than not. Is it more likely that there is jury tampering or not? That's all it is. So if it's 51% that there, 51% chance that there was jury tampering, even if there's 49% of a chance that there was not jury tampering, or if that's how you view it in your mind, so then you have to side with the side of 51%. That's preponderance of the evidence, and that's what the Murdaugh team wants. So they argue in their brief that the standard of proof, the burden of proof in the evidentiary hearing to prove that there's jury tampering is preponderance of the evidence. Now, where's the case law for that? Like we always say, as a lawyer, you've got to provide the legal basis for what position you're arguing for. You can't just say, we think it's preponderance of the evidence, and judge, you just tell me if you think we're right or not. No, you've got to provide the legal authority for that. Now, there's no legal authority in South Carolina for that specific issue. Apparently, anytime that this happened before in South Carolina, there wasn't clear what the burden of proof is. So what they did was the Murdaugh team, they found this case, State versus Barreros in Connecticut, which says explicitly that the burden of proof is preponderance of the evidence in this type of proceeding. So therefore, they're arguing to the court that the burden of proof should be a preponderance of the evidence, just like we find in State versus Barreros, which is a Connecticut case. Now, I looked up that case, and what I couldn't believe that the Murdaugh team did not argue something which is right in that case. It's right in that case. So don't just use the case for the specific issue that you're arguing, that you want preponderance of the evidence. But you know what else that case does? That case takes care of the conundrum and addresses this contradiction between Remmer and Smith versus Phillips. Yes, that's exactly what it does. It says we've got this problem. Everything that I just set up for you in the beginning of this video, that we have this problem between Remmer versus United States and Smith versus Phillips, they address that specific issue, and they go through a whole bunch of different jurisdictions about how the different jurisdictions dealt with this conflict of the United States Supreme Court. And they themselves, in this Connecticut case, in State versus Barreros, they themselves hold that Remmer is really right, and Smith versus Phillips got it wrong, essentially. Now, there's a little bit more nuance in that, but that's essentially what they say. They say that really there is a presumption of prejudice and that the burden shifts to the government, and you do not have to prove as a defendant that there was actual bias, that the juror was actually biased by that communication. So if you're the Murdaugh team and you're actually reading through that case, which I'm starting to doubt whether they actually read that case. I'm wondering if they actually got this quote, some quote of preponderance of the evidence from some sort of treatise or something that just brings down the quote that they need without looking at the entire case. Because if you look at that case, which I did, you just have to wonder, why didn't they show that how that case analyzed this conflict and how it resolved the conflict on your side, on the Murdaugh team side, and say that State versus Barreros actually had this conflict and they resolved it to say that Remmer is the appropriate standard to follow and not Smith versus Phillips. So that was just surprising to me. Now, that is what it all comes down to. So it's all going to come down to how the judge in this case is going to which standard she's going to apply. Is she going to apply the standard in Remmer, or is she going to apply the standard in Smith versus Phillips? In Smith versus Phillips is going to be a lot more difficult for Murdaugh to get a new trial. If she follows Remmer versus United States, it's going to be a lot easier. So that's what it comes down to. That's all it comes down to. What is the judge going to do? Is she going to go with Remmer, or is she going to go with Smith versus Phillips? That's it. That's all it comes down to. Now, let's get to one other area of their brief that they talk about. Now, they talk about some other things and some other arguments, which, like Eric Bland representing jurors, should he be allowed to talk, and things like that, and should Judge Newman be questioned by a judge, and should it be in camera proceeding or should it be in open court, and should they be subject to cross-examination, and how should we talk to the jurors about all this information? Okay, we're not going to get into the weeds of that. I just want to talk about one other significant legal analysis that you have to do with Becky Hill, which I thought is interesting. The Murdaugh team argues in their brief that what happens if Becky Hill asserts the Fifth Amendment? As we know, the Fifth Amendment provides that you are not required to incriminate yourself. So you can't be compelled to testify against yourself. So if you're going to testify that you did something which is illegal, they cannot compel you to do that. So the Murdaugh team makes an argument that Becky Hill should not be allowed to assert her Fifth Amendment privileges, meaning she should not be allowed to say that I assert my Fifth Amendment privileges and therefore I'm not testifying. She should not be allowed to do that. Now, what's the basis for that? What do you mean? We all have Fifth Amendment rights. How come? What do you mean that all of a sudden she should not be allowed to do that? Well, they base that on an opinion, which is a very interesting opinion. I mean, there's so much in this that we can unpack and spend hours and hours and hours on, but that's not what we do here. And this is in the law school class. There's a case called Brown versus United States. And Brown versus United States basically says the following. If you, as a witness, voluntarily take the stand, you voluntarily say, I'm happy to provide you with some testimony. You get on the stand for one side, let's say, let's call it the defense. You get on the side for the defense, and the defense is directing you, right, direct examination, and you're saying all this great stuff for the defendant. Then the prosecution gets up and starts cross-examining you. And then as soon as the prosecution gets up cross-examining, you say, I assert my Fifth Amendment privileges. I take the Fifth. I take the Fifth. You can't ask me any questions. I take the Fifth. Well, that's not right. How can we do that? You can't just get up and say whatever you want and then not subject yourself to cross-examination because you're taking the Fifth Amendment. Either you don't say anything, and if you do say something, then you're opening up the can to cross-examination, and they should be allowed to cross-examine you. And you can't assert your Fifth Amendment rights. That's what Brown versus the United States said. So now, it comes the Murdaugh team, and they say, well, Becky Hill should not be allowed to assert the Fifth Amendment privileges. Why? Because she submitted an affidavit. Her affidavit, she denied any wrongdoing. So that's essentially her voluntarily, under oath, telling the court, I did not do any of this. Well, as soon as you open up that door, and you're voluntarily submitting this affidavit, so then you cannot anymore say, well, then you can't cross-examine me on this affidavit anymore. You can't do that. That's just like Brown versus the United States. So therefore, they're arguing that she should not be allowed to take the Fifth Amendment. And alternatively, they say that if she does take the Fifth Amendment, then we should strike everything that she's ever said. Because you can't have it both ways. You can't say certain testimony and then claim the Fifth Amendment for other things. Now, it's possible. I think it's possible that just by the fact that she submitted an affidavit does not necessarily mean that she cannot anymore assert her Fifth Amendment privileges. Now, well, as we said, during an evidentiary hearing, affidavits are considered hearsay. So therefore, the judge should really not take that into consideration. If Becky Hill refuses to take the stand because of the Fifth Amendment, well, then the judge should completely disregard her affidavit. After all, it is hearsay. Remember, this is how we started off this video. Affidavits are hearsay. They're not admissible in an evidentiary hearing or any sort of hearing where you actually use the rules of evidence. So really, all that the Murdaugh team is going to accomplish, I believe, is that Becky Hill is either not going to take the stand. If she does not take the stand and asserts her Fifth Amendment privileges, then her affidavit should be disregarded. If her affidavit is disregarded, so then it's going to be very, very difficult to argue that Murdaugh should not be granted a new trial. Now again, it's going to come back down to the Remmer versus United States or Smith versus Phillips analysis, which we already discussed. But if she does take the stand, then they do have a point that she should not be allowed to assert her Fifth Amendment privileges. So that is it. That is what you need to know regarding this upcoming hearing. Now you are in the know. You know better most likely than anybody else. And you can either do two things with this information. You can either keep it for yourself, and that way you'll always sound smarter than everybody else, or you can share this with other people and help educate them into what's really going to happen. So that's going to be it for today. If you haven't yet, please subscribe, like the video so we can continue bringing this analysis. See you next time.